but the parties have not come to subscribe their signature. So after vacation, lordship.
I'm for respondent 3, my lord.
Yeah. Have you filed your?
We have already filed.
And you are for respondent?
I have for
He's for
respondent 2.
1 and 3 as they already filed.
You have not filed yours.
I have not.
Mr. Learned Counsel, appearing for the respondent 2 has sought for some more time to file the counter affidavit. Next, Ms. Learned Counsel, appearing for the petitioner, has also sought for some time to file the rejoinder to the counter affidavit filed by the respondent number 1 and 3 respectively. On pre-made by the parties, further time is given to the on pre-made, further time is given to the parties to file the counter and the rejoinder respectively. This is matter of the petition.
Item number 2.
Your Lordship, the state are yet to file the affidavit.
Who's appearing? Yes, Mr. Rinja, you are in this case?
First one number 3 to 7, my lord.
Yes.
My lord, can you see your indulgence, my lord? Can you grant me a week's time, my lord?
All the other respondents have filed.
We are not going to file.
Yes, you are
For the
KCDC.
respondent number 8.
For the respondent number 1 and 2.
Mr. J. Enrique, Learned Counsel, appearing for the Learned G, appearing for the state respondent 3 to 7, has submitted that the counter affidavit on behalf of such respondent could not be filed today and has sought for some more time for the same to be filed. Pre-allowed? On pre-allowed. As prayed for, this is matter on 16.
Obliged.
Item number 4.
Yes, who's appearing?
I'm for Contempt. I think maybe some difficulties for Suhas.
Who's appearing for the petitioner?
Come up after vacation, Your Lordship.
It's a sin.
I don't know. Suhas might be anxious.
None appears for the petitioner on pre-made by the respondent. Mr. S.P. Manta, Senior Counsel, is present on behalf of the respondent number. You're for?
I'm for Contempt as well.
Senior Counsel appearing along with me. I have to. And Mr. Learned Counsel appearing for respondent number
3 to 7.
3 to 7 are present. As prayed for by the Learned Counsel, for the respondent, matters now posted after vacation.
Okay.
Item number 5.
Mr. Nath has reached the gate. I can start with the facts.
So, Please.
Lordship. Lordship, the background facts behind filing of this appeal, they're rather simple, my lord. I'll just take a minute to place the background facts. My lord, the matter arises out of an accident that occurred somewhere in Rebhoy district. On account of the accident, my lord, through the accident, the minor son of the respondent number 1, that is the claimant, was injured, my lord. His right arm was injured. Injured. Right arm was injured, my lord. Treatment was undertaken, etc.
How old was he?
He was 13, my lord, 13, at the time of accident. Consequent to that accident, my lord, consequent to the injury, claim petition was filed in MACT Nongpo. Matter was processed by MACT Nongpo. It led to the passing of the impugned judgment, my lord, 25 April 2024. That is the date of the impugned judgment. Now, my lord, these are the facts. During the course of proceedings, my lord, matter had gone ex parte against the owner and the driver.
Yes.
And, my lord, witnesses were examined, 4 by the claimant, 1 by us, the insurance company.
Yes.
Now, I will immediately go to the judgment and the reasons, my lord, why we are unhappy with the judgment. The first reason, my lord, can be located in the last paragraph, para 36 of the judgment, that is at page 59 of the memo of appeal. Page 59, my lord.
Yes.
Page 59, para 36, if lordship sees what is the amount that has been awarded, my lord.
Yes.
Lordship will see OP number 3, New India Assurance Company Limited is liable to pay the compensation to the claimant of an amount of rupees 13,68,520 along with interest at 9%. Now, my lord, this amount 13,68,520, if lordship looks at page 17 of the memo.
Again, before we proceed further,
Yes, my lord.
is there any no scope for settlement?
Not in this matter, my lord, because one of the grounds is pay and recover was not.
No. Even if it is so,
Yes, my lord.
I believe there could still be a scope for settlement as far as the quantum is concerned.
Respectively,
Thereafter, you can, proceed for payment and recovery.
lordship, one will have to examine, my lord, whether this split kind of settlement can be possible to settle half the issue, half the matters.
If basically there is, I'm not saying so.
Yes, my lord.
Something drastically wrong with the competition.
Right, my lord.
Then parties could agree to a certain
Lordship,
quantum.
lordship, I would humbly submit, my lord, there is a huge deduction that we are seeking. Especially in terms of, in respect of partial permanent disability.
When did the accident occur?
That accident, my lord, occurred in 2013.
Now we are
Exact date, my lord, is, if lordship gives me a moment, 13th May 2013.
so see 13 years down the line.
Yes, my lord.
Is it 13 years? No, 11 years.
9 years.
9 years.
9, 10 years.
Component of interest will come.
Yes, my lord. True.
That has to be taken into account.
Absolutely, my lord.
And of course, the other
Factors are there.
factors are there.
Yes, my lord.
You would be the best person to understand and
My
compute.
lord. My lord.
Be that as it may, I don't know if Mr. Nard,
If lordship allows,
Yes, my lord.
if lordship allows, I'll hardly take 10 minutes in my submissions. If lordship is of the opinion that even the deductions that we're seeking from the awarded quantum are not that significant, lordship may allow us some time to try and work out the matter amongst ourselves. But if lordship is of the view that there is too much of a gap between what we are willing to pay.
So that is why, I think it would be incumbent upon Mr. Nard
Yes, my lord.
to agree to a reasonable rate. Taking in, like we always say, as far as MSc case are concerned, or what are concerned, it should not be a windfall.
Absolutely.
But at the same time, you have to be compensated
True.
for the loss that was
Absolutely.
caused you.
Absolutely.
So,
Lordship,
what do you think?
if I can,
My lord, here,
13 lakhs, isn't it?
13 lakh something. Lordship, if I can humbly suggest, if Lordship allows me to place my submissions and the deductions which I'm seeking, then maybe Mr. Nath can.
That you can do. I allow you.
Then maybe
at the outset, we can cut with all the.
Yes. For example, my lord, if I'm saying that 5 lakhs should be deducted, Mr. Nath can go back to his client and take instructions as to whether they'd be agreeable to that.
Okay, you're saying 5 lakhs.
No, it's an example, my lord.
What would you say now?
Lordship,
Offhandedly.
Lordship,
We are going to all those nitty-gritty.
very well. To cut right to the chase, if Lordship sees, I prepared a small written submission on Lordship's instructions. Lordship will kindly see the conclusion, the last paragraph at page 10. Page 10. These are the deductions, my lord. 5.1, 5 lakhs towards permanent disability. Our stand is there is absolutely no evidence for permanent disability. So 5 lakhs. Connected to that 5 lakhs is a 2,16,000 amount, which was awarded for full-time attendant. But if there is no permanent disability, there is obviously no requirement of a full-time attendant. There is an amount of 1 lakh that, as per this Ajay Kumar judgment of the Supreme Court, is not payable, my lord. Number 4, the rate of interest, which Lordship himself, if Lordship kindly turns the page, in this particular judgment, New India versus Kane Kharsati, Lordship has held to be 6% to be the reasonable amount. So these are the deductions, my lord. 5 lakh would be the major component for permanent disability. Connected to that is that 2,16,000. So 1 lakh, Supreme Court is saying, is not payable.
So you want to get the amount reduced by 8 lakhs or so?
Lordship, I would stretch my neck out and say that even this 2,16,000 on humanitarian grounds, etc., maybe I will not press so much. That I'll leave to for Lordship's decision. But 5 lakhs, my lord.
So 6.
6. Roughly 6 plus a slight reduction in the quantum of the rate of interest, my lord.
Okay. So whatever the case may be, it will come to around 6 or 7.
Yes, because right now, my lord, 13 lakhs with 9% interest would come to a fairly 20-25 lakhs.
Okay. Or the interest part has not been calculated?
No.
So if we suppose now we take 6 as a basis.
Okay.
Plus interest.
Plus
You're
interest,
willing, I mean, that you will not argue. Considering the time span.
What I was saying is that without any deductions, claimant roughly would be entitled to about 25 lakhs. If these deductions are allowed, including rate of interest slight reduction, then it will come to about 17, 18. My very rough calculations, my lord. My very rough calculations. I'm weak in maths, so Lordship will forgive me for that.
You're willing.
Lordship,
I'll be willing. You can persuade your client for that.
Lordship, I will put in best efforts, my lord. I will put in best efforts. I should succeed also.
I think 16, 17 is good enough.
No, my lord, my submission is that the award which has been passed, my lord, is a very just award, my lord. My lord, in fact, my lord, what my learned friend is submitting, in fact, the future income has not been calculated, not been awarded also, my lord.
And that is
the award. That also is required to be added, my lord, which appellate court has got the authority also, my lord. That also has not been done. And what my learned friend is submitting, that there is no prayer for the.
I didn't say that.
But it's not that, my lord. There is a prayer for the permanent injury also, my lord. There is
prayer and evidence are two different things.
Evidence also, my lord, came by the doctor also. Examined doctor stated that there is a permanent disability, my lord. On basis of on considering all these evidence.
Why I'm proposing a settlement, because if we go by way of, I mean, on this path, everything becomes faster. That is the idea. You may get your money within 2 weeks or 3 weeks or a month, but if we go by this route, God forbid, we don't know. If an order is passed by this court, somebody goes on appeal, then what happened? And everything should be reasonable.
My lord, we found that award is reasonable, my lord, very reasonable for them.
9%.
And-
That is settled.
and that's
It'll go down to 6, whatever the case may be.
My lord, it will
Apart
be
from the other aspect,
further treatment is required, my lord. He has to
how
go
old
to.
is he now?
He is now around 22, my lord. 22,
What is he doing?
23. He's not doing anything, my lord.
He's not studying.
He could not pursue his study also, my lord.
Lordship,
Because
I beg to disagree. The evidence on record says that he was at that time he was attending school regularly. He was undergoing no treatment, etc. So it is very well for Mr. Nath to stand up and say that this has happened, that has happened, but there is no evidence for anything, my lord. So if we are on the merits, I'll argue the matter, my lord. But if we are in a mood for
still, my
settlement,
lord,
let's not talk of all this.
Still, my lord, he cannot move his right hand, my lord. He is required further treatment. And it requires heavy expenditure also. My lord, the award which has been
Lower court is called. I don't know. In that case, you see what happened is this court will have to go through the evidence and reappreciate evidence.
True.
But that's
To a
as
slight
the
extent.
case may be.
To a slight extent.
Then we will not be able to complete this case today.
Because from my side, if we are on merits, my lord, it will be hardly 10 minutes if Lordship allows.
No, of course. I mean, I'm not saying that.
We can complete, my lord, because as far as evidence is concerned, my submission would be only the permanent disability part. Only medical evidence is relevant. And medical evidence, there's only a doctor who had come, my lord.
Okay. So scope of settlement gone.
my lord, I hope it will be too less, my lord, for the considering his treatment, my lord. The session which has been given to less the 5 lakhs and interest also, my lord. That is.
But if there's an issue, as Mr. Jindal said, if there's an issue on disability or the extent of disability, whether it's partial or permanent, we don't know, because there's a great difference there. Permanent means that can be understood. Permanently, for the rest of his life, he'll not be able to, certain parts of his body will not be able to function. But if it is partial, it could be healed, in course of time. All those things. All those things have to be taken into consideration when you say the contempt is kept in mind.
Yes.
Permanent healing, my lord, there is evidence that regular treatment is required, my lord. Permanent healing, till now it has not been healed, my lord. It's my submission. After taking the informations and the evidence.
It makes no difference. This is only the first leg of the struggle. The next struggle for Mr. Jindal will come when he runs after the owner and driver.
That'll be my struggle, my lord. And quite a useless struggle it will be.
Considering the life of the young boy, my lord, he has to go long run. That amount, I think 25 lakh is nothing for them, my lord. And there is admittedly there is an accident.
No, that is not.
And just and fair judgment award also has been given. Even judgment has not given the future income also, my lord. Loss of future income also has not been considered.
Anyway, okay, I'll leave it at that. We'll continue with matter will be taken on merits.
Very well. Should I continue? Well, my lord, I was taking my lord through the judgment. So lordship had seen that the first fallacy, the first defect of the judgment is it has awarded a sum of 13,68,520. Page 17 may be looked at, my lord. 17 of the memo of appeal. Now, lordship will see the claim that has been raised, para 19 of the petition.
Excuse me.
Pecuniary damages, my lord, comes to 10,68,520
Yes.
plus non-pecuniary damages 3 lakhs. Totaling the two, lordship will find the amount is 13,68,520. So claimants have claimed a particular figure.
Yes.
The exact figure has been awarded, which is very, very rare in any sort of claim cases, my lord. The reason why on a learned tribunal awarded the exact figure is to be found in para 35, page 59, my lord. Para 35 of the judgment. Para 35. Yes. I'll read, my lord. There is catena of judgments by the Honorable Supreme Court where guidelines have been issued for determining the compensation to be awarded to the aggrieved injured party arising out of motor accident. So I'll pause, my lord. So tribunal refers to a catena of judgments, not a single judgment has been discussed or referred to. In the present case, the claimant has made a claim only with respect of the damages incurred by him for the treatment of his minor son. The claimant has not made any claim with regards to the permanent disability or future prospects of his minor son. This court finds that the claim of rupees 13,68,520 by the claimant is fair enough to compensate the damages caused to the injured minor son at the time of the accident. So the apparent reason why the claimed figure was awarded in totality is because of the opinion of the tribunal that the claimed figure is fair enough. With respect, that cannot be the base. The fact that the presiding officer thinks that a figure is fair enough cannot be the basis of a judicial determination, my lord. The evidence has to be examined, the facts have to be examined, the law has to be applied. None of that has happened. So, my lord, the first broad objection against the impugned judgment is that there is no determinative analysis that has been applied by the trial court in coming to the amount of compensation. First point, my lord. Second point, on the specific issue of permanent disability. Now, as far as permanent disability is concerned, lordship will again kindly go back to page 17, 17. Lordship will kindly see para 19, subpara D.
Yes.
Loss of expected future income on account of permanent disablement. So Mr. Nath's submission of some time back that there was no award for future income. This was the award, 5 lakhs. Claim was 5 lakhs, 5 lakhs was awarded.
Yes.
Now, to award an amount, any amount, in respect of permanent disablement, naturally, medical evidence has to be there on record to show that there has been permanent disablement. So the simple question as far as this aspect is concerned is there any medical evidence? My submission, my lord, is that there is no medical evidence to show or that even whispers the word permanent disablement, my lord. Lordship, the lower court records are there, but just for lordship's convenience, if lordship allows me to place this, the evidence of the doctor. Now, doctor was examined. That is CW4. I'll quickly read from para 3, my lord. Mr. Ronaldo Nongrum, that is the claimant's son, was brought conscious and oriented and had crushed injury of his right arm and forearm. Since the injury was grievous in nature, the patient was referred to higher center at Guwahati for management. Necessary first aid was given to Mr. Ronaldo Nongrum and he was immediately taken to Guwahati. Next paragraph. Shri Khaubol Lintra was conscious and there was another boy involved, my lord. That is Shri Khaubol Lintra. Next page. Oh, sorry. Should be in the back.
Yes.
Shri para 4. Shri Khaubol Lintra was conscious and oriented at the time of not relevant, my lord. I'll skip para 5. Patients were brought on requisition from the police for they had met with a road traffic accident. 6. I have prepared their medico-legal report in one report by my own hand on the same day, that is so and so. On being shown, I identify the medical legal report dated so-and-so, prepared by me, and my signature thereon is the one at paper mark 6, and my signature thereon is paper mark so-and-so. This much is my role in the case. So, my lord, just two things I want to highlight, my lord. Para 3, doctor says that the injury was grievous. Now, again, with respect to doctor, maybe this is an incorrect usage of language, because grievous is an injury that is fatal, that leads to death. I suffer a head injury. 10 days later, I die because of that. That is a grievous injury. It leads to a fatality. So this was not really a grievous injury. It was a serious injury. Maybe that's what the doctor meant. But as far as permanent disability is concerned, the doctor has not said anything. As far as future expenses, medical expenses that may arise, the doctor has said nothing. Doctor has prepared.
He is the doctor who is, perhaps he is the doctor who is on emergency duty then.
He was the first responding doctor, my lord. First responding doctor.
Not the specialist who had come
Not
later.
the specialist who treated. So I'll just come to the specialist aspect also. This doctor, my lord, has prepared a report, a medical legal report, paper mark 6. Paper mark 6, if lordship sees,
Yes.
Prepared by that same CW4. I'll quickly go through it, my lord. Sir, I am submitting herewith the medical report on the examination of the below noted persons as follows. Date and time so and so. Number 1, Shri so and so, that is the claimant's son. Conscious, oriented, has not consumed alcohol. Injury, crush injury of right arm and forearm. Injury is grievous in nature. Again, the same word, grievous. That's all, my lord. The second is for the other patient, not relevant. So again, my lord, nothing about disability, etc. Nothing is there. This is the aspect of the medical evidence on record. The second aspect is no certificate in respect of permanent disability has been brought forward, has been submitted in the tribunal, my lord. So without such a certificate, again, there is a handicap that all of us will face in calculating, in understanding, number 1, whether there is permanent disability, number 2, understanding the quantum, the extent of the permanent disability. Number 3, what lordship had mentioned about specialists, etc. That evidence is also on record in terms of the certificates, etc., the documents from Downtown Hospital. That I have not made copies, but it's there in the LC records. There is my point is very simple, my lord. My point is,
You're referring to?
lordship, the documents, my point is, my lord, none of the documents, including the discharge certificate, speaks anything about permanent disability. Lordship will kindly peruse these documents. They're substantial in nature. At Lordship's leisure, Lordship will definitely peruse. Lordship will see none of these documents are all medical documents stating various tests, various payments, bills are there, vouchers are there, etc. But not a single document in respect of permanent disability or future treatment. So that being the case, the sum total of these circumstances is that there is no proof on record in respect of permanent disability. If there is no proof on record in respect of permanent disability, the claimant stating that he is permanently disabled, the counsel stating that he is permanently disabled, would amount to would not be enough to convince any court, including this honorable court, that yes, in fact, the victim suffered permanent disability of any nature. So the 5 lakhs which has been awarded, for permanent disability, that amount, in my respectful submission, my lord, cannot be sustained. Medical evidence was required. There is no medical evidence on record, my lord. Connected to that 5 lakhs, lordship had seen some time back at page 17. Connected to that 5 lakhs is that amount of 2,16,000 under subpara E, cost of permanent full-time attendant. Now, if there is no permanent disability, there would be no reason to keep any full-time attendant. If there was permanent disability leading to maybe victim being bedridden, etc., permanent full-time attendant would have some place. But here, no proof of permanent disability. The 5 lakhs, my lord, is not sustainable. Similarly, my lord, the connected cost of a full-time attendant of 2,16,000, that also respectfully, my lord, is not sustainable, my lord. That is as far as permanent disability is concerned, my lord. Now, moving on, there is another small figure, my lord, at page 17 itself. Under non-pecuniary damages, there is pain and suffering, 2 lakhs has been awarded, and loss of amenities of life, my lord, 1 lakh has been awarded. Now, if Lordship kindly looks at the written submissions which I had submitted, para 4.7 of the written submissions, that is at page 7, my lord. Para 4.7, my lord, I have extracted a judgment of the Honorable Supreme Court from 2011. This is a judgment of Raj Kumar versus Ajay Kumar. This, my lord,
Yes.
this, my lord, is the judgment, is the leading authority as far as injury cases are concerned, computation of calculation of compensation in injury cases. I'll quickly read this extract, my lord. Para 6. The heads under which compensation is awarded in personal injury cases are the following: pecuniary damages, number 1, expenses relating to treatment, hospitalization, medicine, transportation, nourishing food, and miscellaneous expenditure. 2, loss of earnings and other gains which the injured would have made had he not been injured, comprising A, loss of earning during the period of treatment, B, loss of future earnings on account of permanent disability, 3, future medical expenses. Then non-pecuniary damages, general damages. 4, damages for pain, suffering, and trauma as a consequence of the injuries. 5, loss of amenities and or loss of prospects of marriage. 6, loss of expectation of life, shortening of normal longevity. In routine personal injury cases, compensation will be awarded only under heads 1, 2A, and 4. 1, my lord, will see is expenses, medical expenses. 2A is loss of earning during period of treatment, not applicable here. And 4 is damages for pain, suffering, and trauma. So damages for pain, suffering, and trauma, 2 lakhs has been awarded. Very well, my lord. We cannot dispute that, my lord. Then it goes on, my lord. This judgment. It is only in serious cases of injury where there is specific medical evidence, my lord, specific medical evidence corroborating the evidence of the claimant, that compensation will be granted under any of the heads 2B, 3, 5, and 6. Now, what is 5, my lord? Loss of amenities. So, for loss of amenities, Supreme Court is very clear, specific medical evidence is required. In this case, as Lordship would have seen, there is no specific medical evidence in terms of disability, etc. So, the amount of 1 lakh could appear to be a small amount, my lord, but it is not payable, my lord. It cannot be payable for the reason that there is no specific medical evidence to justify payment of that amount under loss of amenities, my lord. That is the second point, my lord, as far as the quantum is concerned. The third point, as far as quantum is concerned, is the rate of interest that has been awarded, my lord. Now, rate of interest, my lord, that has been made applicable is 9% from the date of filing, that is sometime in 2013, my lord. If Lordship kindly looks at para 4.2 of the written submissions.
Yes.
Now, para 4.2, my lord, we have taken the liberty of referring to Lordship's own judgment passed sometime back in another appeal.
Yes.
That was New India Limited, New India Assurance versus Kane Kharsati. Lordship, I'll read the extracted portion, my lord. Para 26. On the next point of contention raised by Mr. Jindal, that is, the rate of interest, which according to him should not be quantified at the rate of 9% per annum, but in the light of the recent judgment of the Honorable Supreme Court, and considering the economic condition of the country as well as the prevailing rate of interest offered by the banks, the rate of interest should have been pegged at 6% per annum. This court, having considered the authorities cited by the Learned Counsel, that is, the case of Srimati Ronila Chandra Marak versus another versus Aftar Ali and others, in which this court, while order dated so-and-so in MSC appeal number so-and-so, while dealing with the issue of interest in the said case, this is important, relying on relevant judgments of the Honorable Supreme Court, has allowed the interest at 6% instead of 9% to be awarded on the award of compensation given. This being the case, this instant case being similarly situated as far as the issue of interest is concerned, this court is inclined to confine the rate of interest herein to 6%. So, my lord, prior to this extracted judgment, there was yet another judgment that Lordship had passed, Ronila Chandra Marak, my lord. In that judgment, referring to various Supreme Court judgments which we had humbly placed, Lordship had taken the view in that earlier judgment that it should not be 9%, it should be 6%. Following that previous order passed by my lord in this case had also said the same thing. It should not be 9%, it should be 6%. We are seeking.
Yeah, but after this judgment,
yes, my lord.
I think there are also several other Supreme Court judgments,
yes, my lord,
wherein 9% was awarded.
My lord, those judgments stand on a different footing for the reason that those have come on appeal from the lower forums, my lord. Lower forums, MSCT may have awarded, for example, 9%. That quantum of interest was never challenged throughout till the Supreme Court. The challenge may have been on other aspects.
I remember that part of the
yes, yes, my lord. So there was so with respect, my lord, my humble response is that many cases have been decided where 9% may have been the finally awarded interest, but there was no case has gone up where interest was the issue, my lord. What should be the quantum of interest? So interest, my lord, the rule of thumb that was developed by Supreme Court in 2001 itself, in one of the judgments, is that the rate of interest should correspond to the rate of interest offered by public sector banks for FDs. Now, FDs, my lord, Lordship will remember in one of the earlier cases, I had given Lordship a chart also comparing different rates of interest of different banks. Lordship had come to the had seen that no bank is offering more than 5.5, 5.75 is maybe the maximum. 6 if circumstances are exceptional, my lord. So that being the case, Lordship was of the view that following the dicta of the Supreme Court that rate of interest should correspond to bank rate of interest for FDs, Lordship had held that interest should be not 9% but 6%, my lord.
Oh, that's for FD?
For FDs, my lord. For FDs.
Savings would be less?
Savings is much less, 3% or something. That is, I mean, I will not also ask for that.
What would be the current rate now?
Current rate, my lord, for senior citizens is given as 5.75. For others, depending on the nature of the account, etc., 5.5 or 5.
That's the FD.
But senior citizens, 5.75. So, my lord, if Lordship kindly turns the page 5, my lord, just on the off chance, on the slight possibility that Lordship doesn't feel inclined to follow Lordship's earlier order for payment, Lordship, we are humbly, respectfully invoking the doctrine of stare decisis. If Lordship is somewhat inclined, for whatever reason, not to follow Lordship's earlier 6% order, my lord. So stare decisis, my lord, requires this honorable court to follow the same. That's very well established, my lord.
Depending on the facts and circumstances.
True, my lord. So the facts are the same, my lord. It's an injury case with no special circumstances that warrant more than 6%, my lord. So if Lordship has awarded 6% in the earlier case, that should be the same approach in this case also, my lord. My last ground, my lord, can be located in at page 8, my lord, of the submission. Now, in this judgment, the evidence on record, which I will take a minute to take my lord through, shows that the driving license of respondent number 3, the driver, was fake. If the driving license was fake, the ultimate consequence of that is that we, the insurance company, are directed to pay the amount, and at the same time we are allowed to recover the amount from the owner, my lord. That is a very well established doctrine, a very well established principle. If lordship looks at the evidence, there is a form 54 submitted by the police. I can submit a copy, my lord. Form 54 submitted by police. If lordship looks at
Is the accident report?
yes, ma'am. Yeah. Para 7 of this report, my lord. Item 7.
Yes.
Item 7, my lord, is regarding the DL of the driver. Driver is Shri so and so, so and so, so and so. His driving license number is mentioned, my lord. NL05 so and so, ending 779, my lord.
Yes.
Now, lordship, this report, this DL was investigated by a investigator who came before the tribunal to tender his evidence as OPW1.
Yes.
Now, the evidence of OPW1, my lord, para 2, I have investigated the driving license number so and so, ending 779, the same license, purportedly issued by the Office of the District Transport Officer, Waha, Nagaland, and sought for report through RTA application. And I received a report from the Office of the District Transport Officer via the letter number so and so, dated so and so. And as per report, the said license was found to be fake and not issued from the Office of the District Transport Officer, Waha, Nagaland. So, my lord, very clear, crystal clear evidence, my lord, that the license was fake. Now, if the license was fake, as I had submitted a minute back, the consequence is that we are directed to pay with the simultaneous right to recover from the owner. But, my lord, if lordship peruses the judgment, lordship will see that from paras 23 to 31 of the judgment, I will not take up time of this honorable court by going through each and every of those paras, but paras 23 to 31,
Yes.
there is extensive discussion by the tribunal on this aspect.
Yes.
23 to 31, well, there is extensive discussion, but with respect, my lord, I need to point this out. It was an unrequired discussion, because what the tribunal discussed was whether, because the license is fake, we, the insurance company, should be released from all liability. And the remedy for the claimant, if anything, should be against only the owner, my lord. That was not what we were trying to impress upon the tribunal, my lord. So 23 to 31, she has gone on discussing a lot of cases, etc., a lot of judgments, etc., and has come to the conclusion that we could not establish that the owner knew that his driver's license was fake. Because we could not establish that the owner knew that the driver's license was fake, we cannot avoid liability. My lord, I agree with that, my lord. It's next to impossible to prove that the owner knew or did not know that his driver's license was fake. But having acknowledged that the license was fake, and it has to be acknowledged in view of the evidence on record that the license was fake, we should have been held liable. We bow down to that. But at the same time, my lord, we should have been granted the right to recover, my lord. And the right of recovery, my lord, is a very well established doctrine. Page 9, my lord, para 4.10. My lord, para 4.10, I have extracted the first judgment of the Supreme Court where this doctrine of pay and recovery was formulated. This was New India versus Kamla, 2001 judgment.
Yes.
I'll just quickly read the underlined portion, my lord, towards the end of the page. Underlined portion. This means the insurer has to pay to the third parties only on account of the fact that a policy of insurance has been issued in respect of the vehicle. But the insurer is entitled to recover any such sum from the insured if the insurer were not otherwise liable to pay such sum to the insured by virtue of the conditions of the contract of insurance. If I can turn the page, my lord. Underline portion again, my lord. But the amount so paid by the insurer to third parties can be allowed to be recovered from the insured if, as per the policy conditions, the insurer had no liability to pay such sum to the insured. Next para, my lord. Insurer is not liable to the insured if there is violation of any policy condition, but the insurer who is made statutorily liable to pay compensation to third parties on account of the certificate of insurance issued shall be entitled to recover from the insured the amount paid to the third parties if there was any breach of policy conditions on account of the vehicle being driven without a valid driving license. So, my lord, the rationale behind pay and recover is very simple. Lordship, I'm certain, is aware of the rationale, my lord, that my policy, the policy I have issued, has been violated because a person without a license has driven the vehicle. So, strictly speaking, the contract between me and the insured has been breached. If there is a breach of contract, I am released from the contract, from my obligation under the contract, under normal principles of contract law, my lord. However, this being a social welfare legislation, etc., the view of the Supreme Court is, why should a third party, the claimant, suffer because the owner employed a driver without a proper driving license? So third party not being made to suffer means that I should pay, but I should recover from the owner, my lord. So claimant has no role to play in this. Claimant will receive whatever is rightfully entitled for the as far as the claimant is concerned. So, my lord, I sum up the conclusion. My lord, I have already taken, my lord, through the conclusion in my written submissions. My points are very simple, my lord. My points are that the first point is that any sum payable under an award, there has to be evidence for that amount. Permanent disability, there is a claim. In the impugned judgment, the tribunal for some reason had taken the view that there is no claim. Evidently, there is a claim for permanent disability, future income in respect of that. Claim is there, but there is no evidence, my lord. The only evidence that could have been there is medical evidence. Merely to state that he is permanently disabled, my lord, is not enough. So 5 lakhs, my lord, has to be deducted. 2,16,000 is connected to that for permanent attendant, full-time attendant. Right at the beginning, I had said I will not press on that. I leave it up to lordship, whether lordship thinks that if permanent disability is not there, how can there be a full-time attendant? Whether 2,16,000 is payable or not, I leave it up to lordship's discretion, my lord. Rate of interest, my lord, 9% to 6% should be, may be kindly awarded. And lastly, my lord, 1 lakh, which has been paid towards loss of amenities. Supreme Court is very clear. There has to be specific medical evidence in that respect. There is no such specific medical evidence, my lord. That being the case, my lord, this award I submit is liable to attract certain deductions. The exact nature and quantum of deductions I leave to lordship's good judgment, my lord. That's all.
No, but you should have come up with a figure.
The figure is in the last paragraph, my lord. The deductions we are seeking, 5 lakh plus 216 plus 1 lakh.
Where is it?
Para 5, my lord, page 10. What I had pointed out right at the beginning. Para 5.
Like I said, what according to you would be your liability?
This is there, my lord. Liability would be 13.
I mean, you have stated, no doubt.
Yes, my lord.
Minus, but
yes, my lord. The exact figure I can just quickly calculate and give it, my lord. If all these sums are kindly allowed by Honorable Court, then, my lord, the awarded principal amount would be reduced by about 8 lakhs. So that will be 13 minus 8, roughly 5 lakhs something, my lord. If everything is allowed, my prayers are allowed. However, lordship may not do that. So lordship, as I said, I leave that up to lordship.
Where's the prayer for future?
Lordship, it's contained in that page 17 only. It's contained there only. If lordship carefully sees page 17, 17, subclause D, 19D, loss of expected future income on account of permanent disability.
But for argument's sake,
yes, madam.
Even if we don't take, you see, permanent disability as the case,
yes, madam,
surely there would have been partial disability, which would impair, his functioning.
Lordship, with respect, my lord, that will be an assumption in the absence of medical evidence.
True. No, you see, medical evidence would say that his injuries are grievous. To what extent we don't know.
We don't know.
But we'll have to go by what the doctor says.
True, my lord.
Only the disability part has not been, quantified.
Yes, ma'am.
Or rather, distinguished.
Proved.
But if there is no permanent disability, surely there would be partial disability.
Lordship, again, with all respect, my lord, to reach that conclusion in the absence of medical evidence would be an assumption, my lord. To say that surely there would be...
Then the extreme would be that there is no disability at all.
That would be the extreme, and the evidence shows he's attending school and he's not undergoing treatment. Taking that into consideration, the assumption may be...
Would he be able to use the hand as it is?
We don't know, my lord. There is no evidence, my lord. The witnesses should have been better questioned with respect, my lord. But there is no statement saying anything, my lord.
Well, there must be some judgment as far as this issue, this portion is concerned.
Lordship.
Because though there are no specific evidence,
yes, my lord.
But courts are always the issue of
just to assist
probability has to be
just to assist honorable court. I can draw lordship's attention to the well-known principle under MV Act is that at the time of awarding compensation, tribunals and appellate forums also can indulge in certain guesswork, my lord.
That is,
so it'll have to be guesswork at the end of the day, but the extent of the guesswork, lordship, that lordship will have to
everything has to be
balanced.
It has to be on the tested on the anvil of reasonableness.
That's true. That's true. Obliged.
Yes, Mr.
What my learned friend has disputed about the permanent injury and my lord, interest at the rate of 6% and driving license. And my lord, earlier the last submission there was a submission that for pay and recovery situation, my lord. My lord, there are what my learned friend has submission now about the injuries, my lord, permanent injuries. My lord, there are judgments in regard to the payment of just compensation, my lord, the proper compensation. And there are judgments, my lord. I may be allowed to submit it.
Payment of just compensation is there.
Yes.
But how do you reach that stage? It has to be based on evidence.
Yes, my lord.
So how can you justify from your evidence?
In the evidence, my lord, medical evidence is as my learned friend has showed.
Mr. Nard, you are very
yes, my lord.
You are seasoned enough to understand that in MSc cases, there must be you have to prove permanent disability. A certificate has to be exhibited. Once you exhibit the certificate, then that's accepted. Which doctor has to be has to examine the injured and so on and so forth. Anyway, leave that aside.
Understand, my lord. My lord, let it come on Monday. My lord, I'll submit all the additionals. Some additions are there also, my lord, in regard to the rate of interest, in regard to the date from which interest will be calculated. My lord, since in last occasion it was only the submission for pay and recovery discussion. That is why, my lord, I did not bring it, my lord.
Whatever the case may be, as far as the pay and recovery portion is concerned, there is no, it is accepted by the appellant. The only thing is that it is incumbent on this court to ensure that there is just compensation is given.
And fair.
So we cannot just accept whatever is there. Since the evidence is now under challenge, we'll have to look at it. But now you say you're not prepared today. I thought Monday would not be possible. Because Monday is will be 9th.
9. Tuesday, my lord. Not Tuesday.
The
Wednesday, my lord.
Judgment may not be able to be prepared. I have some other
For only 2 days I am required, my lord, to get all those papers.
Friday is convenient, my lord.
Friday. Monday is convenient, my lord. If you convenient of the court.
Okay, we'll see whatever the case may. We'll take it up on 13th.
13th. Obliged. Obliged.
Heard Mr. S. General Learned Counsel for the appellant, who has concluded his argument as far as who has concluded his argument. Mr. H.R. Nath, Learned Counsel for the respondent, has submitted that he may be allowed to present his case in on the next date fix. As agreed to by the parties, list this matter on 13th.
Obliged.
May please, Lordship. Lordship, I beg to mention item 9 and 10. It's connected matter, Your Lordship. Item 12 also it's connected matter, Your Lordship. 9 and 10.
Is for paper.
Lordship, I pray that this matter may be listed after vacation.
9, 10 and 12. Your
Item number 2.
from the same judgment.
Yes, from the same judgment.
Premier by the appellant. Not objected to by respondent. Matter is adjourned. As prayed for, list the same after vacation.
Obliged, Lordships.
I beg to mention item 14. Come up to vacation, Lordship, please.
Okay, Lord. Same order.
Obliged.
May please, Your Lordship, I beg to mention item number 11.
No.
Same order. Yes.
Obliged, Your Lordship.
Supplementary list, item number 1.
Very good, pleasure. This is a statutory appeal against conviction on 302 year. So conviction against the order 39/2024. Your Lordship, I have come, and that judgment is at 25. Your Lordship, and sentenced to life. There are 3 convicts, they are sentenced to life. I am moving on behalf of two convicts, I am moving, Your Lordship. So what has happened, in fact, these 2, they were roped in for a common intention. They were never involved in the assault, Your Lordship. The evidence I can just show in the PWs. What happened, just 34 common intention, they roped in, and no one had identified them also. They have identified only their father, one of the main accused, who is there. Of course, for him, the next appeal is there. Mr. Sheikh is moving. So I'm moving bail for these 2 because they were nowhere involved in the incident at all. To that effect, if Your Lordship please to come to PW1, that is at page 104. I am moving for 2.
Since you filed the appeal.
Yes, appeal.
It's against a judgment and sentence passed by the
Session Judge West Garwels.
So we'll admit the appeal.
So, if Lordship please to consider for the bail, because I want to highlight few things before Your Lordship.
Sentence is life.
Because why?
We'll hear the appeal, Mr.
Lordship will hear the appeal.
You can expedite with preparation of the paperwork.
That will be done. But in fact, my humble submission, Your Lordship, there's nothing against this 2 convict.
That will be looked into. Because what you will have to do is, you have to lead us through the evidence.
Yes, yes.
See what is wrong with the evidence.
Yes, yes, evidence.
And the materials and also the the findings in the judgment. Yes. That will entail a proper, rather full-fledged hearing.
Then, as Your Lordship please, that appeal may be kept. Bail may be kept. Yeah, to hear in the next day when the paperwork comes. Immediately, I'll make it. Otherwise, from the deposition also, if Lordship is pleased to see, then Your Lordship will arrive at that they no way involved.
See.
And they identify also in TIP also they were never identified.
Next date.
One accused person was identified in the TIP.
One that is moved by Mr. Sheikh, not by.
Heard Mr. SP Matar and Senior Counsel, along with Mr. Direct Counsel for the appellant, who has submitted that this appeal has been preferred against being aggrieved, the appellant's hearing being aggrieved by a judgment and order dated 30/9/2024, passed by the
Session Judge, please.
Sessions Judge in Sessions Judge. Which district? West Garwels. In Sessions case number 21 of 2017. On consideration of the submission made, this appeal is hereby admitted. The lower court records, the trial court's record are directed to be produced for this court on the next date fix. In the meantime, the appellant is directed to prepare the paperwork. Respondent is only the state.
Only the state.
The respondent being duly represented by Mr. H. Kharmi, additional PP. No formal notice is required to be issued upon such respondent. As paid for, this is matter after petition. In the meantime, as prayed for by Mr. Mahanta, the issue of suspension of the sentence oblique bail to the appellant herein would be considered in due course.
Item number 2.
Same arising out from the same judgment and order, Lordship.
You're also pressing for suspension of sentence?
No, I haven't filed, Lordship. Let paper book come, then only I'll.
Same order. I know something about it. Last pushing to suspension of sentence,
Apply, Your Lordship.
Item number 3.
Oh, this is
Your Lordships, we have received the affidavit filed by the respondent, and we pray for after vacation to file the rejoinder, Your Lordship.
Ms. Learned Counsel for the petitioner has submitted that on receipt of the counter affidavit filed by the respondent, sometime may be allowed for the rejoinder to be filed. Pray allowed. As pray allowed. On consent by the parties, list this matter to vacation.
Obliged, Lordship.
Item number 4.
May it please your lordships, I'm appearing on behalf of the respondents. However, due to the inability of the conducting counsel to appear today, I pray that the matter will be listed after winter vacations.
Mr. Learned Counsel for the respondent has submitted that the senior counsel, Mr. B.J.K. Kanta, who is leading the case, is still not fit to appear before this court on grounds of personal difficulty. And as such, it is prayed that this matter may be adjourned and to be fixed after the vacation. Mr. Indishurai Learned AG, appearing for the appellant, has no objection to the prayer made. Allowed. List this matter accordingly.
Apply.
Item number 5.
Lordship, in this matter, we are required to prepare the paper book. I'm seeking some more time.
Pardon, Mr. M. No pure Learned Counsel for the appellant was submitted that the paper book could not be prepared today and has sought for some more time for the same to be prepared. Pray allowed. On pray made, list this matter up to vacation.
Apply, Your Lordship.
Item number 6.
Lordship, I pray for some time to prepare the paper book, Lordship.
Not pressing for the missed case. Ms. Learned Counsel for the appellant has submitted that the paper book could not be prepared today and has sought for some more time for the same to be prepared and filed before this court. As prayed for, same is allowed. As far as the application, as far as the prayer made in the criminal miss case number 106 of 2024 is concerned, no prayer or argument has been advanced in this regard. The same will be heard on the next date fix, if so pressed. As prayed for, this is matter to issue.
Much obliged, Lordship.
Item number 7.
In 7, Your Lordship, I have a similar prayer, Lordship, for preparation of paper book, Lordship.
Preparation of paper book?
Lordship.
You order, ma? Same order.
Obliged.
8.
Item number 8.
May I please, Your Lordship, this is an application for condonation of delay of 13 days against an order and judgment and order passed by a special judge Pukso.
Have you issued notice?
No, Your Lordship.
No order has been passed?
Not yet. Today is the first time.
Today is the first day.
I can hear you.
Yes.
How many respondents are there?
There are 5 responses. Yes.
5 respondents.
5 respondents.
3, 4. I'll be appearing for 1 and 2.
These respondent 3 and 4, are they relevant?
3 and 4 are the complainant, Your Lordship.
For complainant?
Yes, Your Lordship.
Mother, father?
I'll be for 1 and 2 only. Your Lordship.
Could order pass my name?
And, Your Lordship, we have also filed a suspension.
It will be heard on next date.
Maybe taken up next week, Your Lordship.
First, the condemnation petition has to be heard. You take steps for issue of notice. See what else.
See what.
Oh, yes. Yes, I didn't realize. My brother has just pointed out. It appears, as far as respondent 5 is concerned, you have given the details, if not the exact name. So anybody who reads this and who is known would know. I believe as far as this, just one line would be sufficient.
Miss X.
Yes. Miss X, that's all.
That's all. It's corrected, no?
Yes, I will correct it, Your Lordship.
Since you have not taken step for issuing order, in your copy also you can just...
No, absolutely. She can correct it with the permission of the court in the registry before issuing notice.
You just paste a paper over here. It's
Okay.
initial.
We'll do that, Your Lordship.
We'll not pass any formal order on that. You just do it now.
Yes, Your Lordship.
Or in course of the day, whatever.
Just correct it. And then you take steps after correcting.
Okay. Item number 13.
Oblige also.
May please, Your Lordship. This is an appeal against the judgment dated 28/3/24, passed by the Session Judge of July. My main contention is that the circumstances evident adduced by the prosecution do not form a complete chain pointing to the guilt of the accused, and the benefit of doubt is to be given to the accused person, appellant. In this case, my lord, the FIR is in page 3 of the paper book, my lord.
Yes.
Page 3, my lord. I am writing this complaint before you that on 2/9/2005, my son Rishan Ki BM was murdered by Aloy Suyam at night time in Saphai, Kempreng village, nearby road. I also do not know the reason behind why the murderer did so. The incident was witnessed by Ling Langstang. Actually, it should be Moni Langstang, but there is a mistake. I have informed about this incident to the in-charge of company on 4/9/2005, and from his end he has done his duty as per the law. When he filed it at company, it was sent to GUI and was formally registered as registered by GDE number 147 dated 6/9/05 at 11 AM and registered as GUI PS case 121/9/05 under section 302 IPC. SB Singh in charge company opposed is entrusted with investigation of the case. So during the investigation, my lord, and then ultimately a charge sheet was submitted.
Yes.
Charge page, you know. Page 14, my lord, is the charge sheet. And the type copy is in Page 18. The prosecution have examined witnesses. Examined witnesses, 8 of them. Page 21, my lord.
21.
Page 21. Yes, examined 8 witnesses.
Yes.
And after examination of those witnesses, was sent to the court, and by
not 8 witnesses, 7 witnesses, Your Lordship, because 1 expired.
Anyway, but in the list of 7.
Oh, the list is 8.
8, yes.
But
1 expired.
1 expired in before he could be, his evidence could be recorded. Okay.
1 expired, yes. I think Jipasa, and in his place another doctor has come. So it comes same thing, almost same thing only. It's official witness only.
Official witness?
Yes.
So altogether 8 witnesses were examined?
Yes, 8. Because Jipasa is the one who died, I think.
Okay.
The doctor.
No, I think number 3 in the list, Your Lordship, he expired. Lordship, kindly come to page 17. That is the original. Kindly see at serial number 3. Assistant Tinkan, Your Lordship. There is a expired, it appears, Your Lordship.
Silent Tinkan.
Expired.
Expired, same, yes, Your Lordship. 7.
Yes, because you see, look at the notings.
Lordship,
it says
yes.
PW1,
Expired.
PW2,
Expired, yes.
PW3 is number 4.
Number 3. Number 3, Your Honor.
Lordship, 3 he expired.
Yes, that's what.
And then
Serial
serial number 4 he
Serial-
became the PW3, Your Lordship.
Understood.
Is there. PW3 is there.
No.
Number 4, in the serial list, number 4, of course, is expired. Expired, page 17.
Number 3 has expired, not number 4.
Number 3.
Number 3. Number 3, yes. Number 3, yeah.
So number 4 becomes PW3.
PW3.
Yes.
Cut to the second, page 24. The deposition start from page 24 onward, my Your Honor, my Lord. The deposition of PW1, Linus Sumer, my Lord.
Yes.
I received a summons from the court. I know the case. At the deceased victim, I'm not doing it, it's a charge, me. Sorry, Your Honor, my Lord, then it was charge was framed, and then
Charge at page 22.
22. Type copy is 23. Name of office magistrate.
How many heads? 1 head.
1 head. 302. And thereafter, my Lord, the witnesses deposed before the court of the district and session judge, my Lord. And then The statement of the in page 24, my lord, the deposition of PW1, Linus Sumer. Linus Sumer, son of late LBM, aged 55 years. So and so, and then I received a summon from the court. I know of the case as the deceased victim, Sri Rishan Ki Biam, is my elder son. On the day of the incident, I was in the jungle extracting coal. I cannot remember the date of the incident. On that date, I returned home at about 4 to 5 p.m. and found that my son, who was aged about 19 years, was not present at home. Accordingly, I with some of my friends went to search for my son and found his dead body lying in the garden. On seeing the dead body of my son, I cried and reported the matter to the police. Exhibit 1 is the FIR, and Exhibit 1 by 1 is my thumb impression. After reporting the incident to the police came to the PO, and thereafter I do not know anything. It was crossed by the defense counsel, my lord. I cannot remember who wrote the FIR, and I am not understand the content of the FIR. I do not know who murdered my son. That's all I have to say. So, then PW2, my lord, is the deposition of PW2 is Morning Langstang. He was the resident of Sapai village. I received a summons from the court. I know of the case as the deceased victim is from the same village.
Yes.
Since the incident happened long time back, I cannot remember the date of the incident. On the night of the incident, I was in the house of my wife and left the house of my wife's grandmother at about 9 p.m.
Yes.
Which is a walking distance of about 15 minutes. On the way to the house of my wife's grandmother, I met the deceased Rishanki Biam on the village road near his house. The deceased asked for a biri from me, and I gave one biri at that moment. At that moment, the accused Sri Aloysa Suyam reached the place and suddenly assaulted Rishanki Biam. As it was dark, I could not see from where the accused assaulted the deceased. I also know the accused person who is present in the dock today, as we belong to the same village. I asked the accused person why he assaulted the deceased, Rishanki Biam. He instead threatened me, and I fled away to the house of my wife's grandmother. On reaching the house of my wife's grandmother, I informed about the incident. I spent the entire night in the house of my wife's grandmother. I was present at the PO when the police arrived and told them about the incident. After about 5 days, I was asked to come to court, and my statement was recorded before the magistrate. I told the magistrate about the incident, and I was also asked to put thumb impression on my statement. Exhibit 2 is the deposition, and Exhibit 2 by 1 is my thumb impression. In the cross, my lord, I do not know with what weapon the accused person hit the deceased. The accused person was intoxicated at a time when he assaulted the deceased victim. It's also a fact that the deceased victim was smelling alcohol at the time of the incident. That is all I have to say. Then PW3, page 26, my lord, is the deposition of PW3 Willingson Dhar. I received a summons from the court. I vaguely remember of the case, and I know the accused person, Aloy Suyam, and I also know the deceased victim, Rishanki Biam, as we were residents of the same village. I do not remember the date and month of the incident, but only remember that I attended the funeral of the deceased victim. On the day of the incident, I was working at my paddy field situated at the outskirts of Safai village. I am also the church elder of the Catholic Church of Safai village. I was informed about the incident, and on the day of the funeral, I performed the funeral rites of the deceased. After learning about the incident, I visited the house deceased and have put my signature of the seizure list as a seizure witness. So this is very important, Lord. After learning about the incident, I visited the house of the deceased and I put my signature of the seizure list as seizure witness, and Exhibit 3 is the seizure list, and Exhibit 3 by 1 is my signature, and material Exhibit by 1 is the wooden firewood, length 24 inches. In the cross, here I replied, I do not know about the incident as I was not present in the village. I do not know about the incident as I was not present in the village. I do not know who committed the offence. Then people 4 is was the policeman.
Yes, yes.
Birendro Marak, son of late Jengje Sangma. I received someone to depose for this court. I am serving the police department, Government Meghalaya, and joined the service in the year 1986 as ASI and promoted to the rank of SI in the year 2004. And again promoted to the rank of inspector in the month of July 2015. I am presently posted at Laban Police Station as traffic in charge. In the month of September 2005, I was posted at JYPS as officer in charge. On 6/9/2005 at 11 a.m., received an FIR GDE number 147 dated 6/9/2005 from the complainant, Sri Linus Sumer of Sapai village, and the case was registered from the complainant Sri Linus Sumer of Sapai village, and the case was registered by JYPS case number 121-9 of 2005 under section 302, and the case is endorsed to IOSI Bising. Outpost for investigation. Exhibit 1 is the FIR and Exhibit 1 by 2 is my signature. Defense counsel declined to cross. Then, my lord, it comes to the page 28, the position of Suniki Lingdo. Suniki Lingdo is just so he is by a commission advocate, of course. I received a summon to depose for this court. I am serving the police department, Government Meghalaya, and joined service in the year 2014 as UB Constable 292 and presently serving as a company outpost. I am executing officer in connection with the instant case. On 11/12/2015, a summon was received at the outpost address to Srimati Rani Suchiang. The OC endorsed the same to me. Accordingly, on 10/1/2016, I proceeded to Sapai about the whereabouts and address of Srimati Rani Suchiang. However, they told me that no person by the said name reside at Sapai village. Thereafter, I went to confirm about the same from the headman CF Sapai village, who told me that there is no person residing in the village by the name of Rani Suchiang, and there is no record of the person to prove that she is the resident of Sapai village. To substantiate his claim, the headman has put his signature on the reverse of the summon Exhibit 4. It is a summon dated 2/12/2015. Then page 29 is the deposition of the doctor. I retired as a medical superintendent of Juwai Civil Hospital in 2013 on voluntary retirement after serving since 1982. I know late Dr. G. Pasa, as we are serving together at Civil Hospital, Juwai, till his retirement in 2011. And late doctor has since expired. On 5th September 2005, 11 a.m., late Dr. G. Prasad conducted a post-mortem on the dead body of late Rishanki BM, 16 years of age, male, Penar by caste. The dead body is the average build, height and size. The dead body is in the process of decomposition. Tongue is protruding and also the eyes. Injuries: multiple small abrasions on the head, face and whole body. There was a broad lication mark on the front of the neck. Small abrasion multiple on the frontal and parietal region of the scalp. More detailed description of the injuries. Compression to the neck, strangulation leading to asphyxia, which is fatal and ante-mortem in nature. In the opinion of late Dr. G. Prasad, the cause of death was due to the violent asphyxial death. Weapon: broad lication. Exhibit 4 is a post-mortem report prepared by G. Prasad. The dead body was identified by Shri Kalita BM, uncle of the deceased. Then page 30, my lord, is come the statement of James Decantan Suchang. He is a retired government servant. I received a summons to appear for this court. I joined the service in the year 1978. The matter was endorsed to me on 19/9/2005 by the then ADM, the Blue Nang Si, for recording the confessional statement of the accused person. The accused was brought to my chamber on 21/10/2005 at around 12:30 p.m. from District Jail, Juai. I have complied with the provision under Section 164 CRPC, and a 3-hour reflection time was given to the accused person. The accused person confessed that he had committed the crime. Exhibit 5 is a statement recorded by me, and Exhibit 5/1, 5/2, 5/3, and 4 are my signature. It's a fact that I had administered oath to the accused person. I had administered oath to the accused person before recording the confessional statement of the accused person. During the reflection time, the accused person was asked to be in the custody of the police for 3 hours. The accused person knows that I am a magistrate who will record his statement. The accused person was comfortable when he was brought before me. It's not a fact that I have not complied with the provision under Section 164. I cannot remember what crime was committed by the accused person. It's a fact that I have not mentioned in the statement recorded by me the nature of the crime committed by the accused person. Then page 31, my lord, the portion of PW7 in English language. This is a policeman. I received a summons to appear to report for the court. I joined police service in the year 1983 as ASI and promoted to SI in the year 1992 and was posted at Tura. In the year 2004, I was transferred to Juai PS and posted as in-charge company outpost. The instant case was endorsed to me by OC Juai PS on 6/9/2005 for investigation. Accordingly, I took up the case. During investigation, I have visited the PO, drawn sketch map, and held inquest over the dead body of Shri Rishanki BM, alleged to have been murdered by accused Ali Suyam, and the dead body was sent for post-mortem. During investigation, I have seized one wooden firewood length about 34 inches on being led by the accused person. Thereafter, the seizure list was prepared. Exhibit 3 is the seizure list under so-and-so. Exhibit 3/2 is my signature. Witnesses have also been examined in connection with the case. The material exhibit is brought and produced before the court today in a packed condition, and the same is opened in presence of the prosecution, defense, and accused for identification by witnesses. And being shown to me, I state that the material exhibit is a wooden firewood about 34 inches length, seized by me in connection with this case. After completion of the investigation, the case was supervised by the CI, who produced the case diary and passed an order to submit charge sheet against the accused person, Sri Aloy Suyam, as accordingly I have submitted charge sheet by CS number 2/2006 dated E1/2006 under section 302 against accused Aloy Suyam. Exhibit 6 is a charge sheet and Exhibit 6/1 is my signature. Then the cross matter. The incident took place on 2/9/2005. The FIR was lodged on 6/9/2005. I agree there is a delay in lodging the complaint, but I did not record the reason for delay, as it was received by the OCGY PS. The PO was not disturbed till the time I arrived. I have not noticed any blood stain. I have not noticed any blood stain on material exhibit 1 when it was seized. I did not leave any fingerprint from material exhibit 1. I have no idea if there is any enmity between the accused person and the deceased victim. I prepared the exhibit 3 at the place where the material exhibit 1 was found. The incident took place at 9 p.m. The accused person was arrested on 6/10/2005. There are few eyewitnesses in this case. The main eyewitness, Morning Langstang, saw the incident as he came along the accused on the night of the incident, though there is no sufficient light in and around the PO. I seized material exhibit 1 on 15/10/2005. I do not agree that the material exhibit was not the one seized by me in this case. The incident took place on 2/9/2005 and the material exhibit 1 was recovered on 5/10/2005. The PO where the offence took place is called at Kerpreng Sapai. Material exhibit 1 was seized from Sapai village. I have no idea if the accused has any motive for commission of the crime. The accused was arrested on 6/10/2005. The seizure witness have put their signature at the spot where the material exhibit was recovered. I did not inquire if the accused is known to the deceased victim. I have held the inquest over the dead body in this case. I found that the dead body was injured in the backside. I didn't collect the blood stain from the cloth of the deceased victim. I did not agree that I have cheated the case on being directed by the CI, but is based on investigation. I do not agree that the accused person has been falsely implicated in this case. Ini di discussion, correct?
Yes.
Now, my lord, I come to the discussion because this case, I will humbly submit the Leonard District and Session Judge, my lord, fell in complete error in placing reliance upon statement and in convicting the appellant. Now, I will discuss, my lord, regarding the statement of the witnesses based on the. Now, I'll start from the postmortem report, my lord. Postmortem report is in page 55. So if you go through them, in page 55, in my opinion, the cause of death was due to the violent asphyxia death, weapon, manual, a broad ligature. That is the opinion. So in this case, my lord, if we see from the postmortem, is through by asphyxia and the broad ligature. Ligature, that means somebody tied with a rope or with a thread. Does not tally, my lord, with what the other witnesses, the finding and of the other witnesses, in which you see that from the material exhibit, my lord. If you go through, my lord, in page 47, the seizure list, as abusing, do hereby accompany today on 15/10/2005 at 5 p.m. says below noted article being led by the accused Aloysius in connection with the above noted case. The seizure has been made in presence of the below noted witnesses. The wooden fire length of 34 inches and it was witnessed by Silent Khan, headman, and Williamson Dahar. So as pointed out earlier, the Silent Khan was dead, man. Is dead, already expired. Now the one who is still who is alive and examined is only Williamson Dahar, a church elder. B3. Yeah. Church elder. PW3. Williamson Dahar is a PW3, my lord.
So according to the IO, this is the murder weapon?
Yes. No, he did not say specifically anything.
Let's see, then
He did not say
why would you seize this?
Because, my lord,
was the discovery of this this wooden plywood, was it led by the accused?
Nothing is clear because in the evidence, my lord. Because this, if you go through the whole judgment, my lord, the judgment it is based entirely on PW2, my lord. PW2, and PW2 is contradictory with the finding of the postmortem report, as the PW stated that the appellant had assaulted the deceased, while the cause of death in the postmortem report was recorded as compression to the neck. So if you go through the postmortem report and the statement of PW2, it does not tally, my lord. And I'll come also to that he is that PW2 is unreliable, unreliable. Now, my lord, how much is unreliable, we'll see that in page 25, my lord. What does PW2 say? In page 25, I received a summons from the court. I know the case as the deceased victim is from the same village. Simulate. Since the incident happened long time back, I cannot remember the date of the incident. On the night of the incident, I was in the house of my wife and left for the house of my wife's grandmother. On the night of the incident, I was in the house of my wife and left for the house of my wife's grandmother at about 9 a.m., which is walking distance of about 15 minutes. On the way to the house of my wife's grandmother, I met the deceased, Rishanki BM, on the village road near his house. The deceased asked a biri from me, whereas in page 60, my lord, he stated that page 60, my lord, he stated that this is deposition I've been nested about 20 years. My name is Morning Langstang. My father's name is Son.
This is 164.
Pardon?
This is 164.
No, this is this is 61.
161.
Page 25.
No, page 25 is
No, we're talking about page 60.
Now how different it is, the way of statement. In page 60 different and page 25 different.
True, but
that is what I want to show.
I think this should be 164.
No.
Page 25, that is the deposition before
That is the deposition in court.
Before the court.
But 60 should be either 161 or 164.
It was
This
164.
Like, this is 164.
164.
That's what I mean.
164, yes. Right. 60. My father name so and so, where I am by profession a farmer, and on 2nd September 2005 at about 9 p.m., I left my mother's house to go to my mother-in-law house. Where my wife also staying together. But on the way I met the victim. So that also is the decision on the libel. In one before the court he keep one statement, and in 164 he keep another statement. That he go to my mother-in-law house from my mother house.
I don't know. See, this is a type copy. Where is the original of this? Is this page 59? Can't even see.
Original is yes, sir. It's a bit unclear. 59. Yes,
So this is a type
59.
Copy. You see, you have to remember sometimes type copy and the original copy there might be some difference here and there. Apni kaha to record?
But original record of the code also is here, I think.
Yeah, that's what we look. This is a thumb. Because this has been, you see, this statement has been exhibited as exhibit 2, according to him.
Because the court rely on this statement.
No, while typing you have not shown it is whether it is exhibited or not.
Yes, exhibited.
This is exhibited.
I think
the type copy do not show that it is exhibit 2.
Lordship, kindly come to page 59.
Yes, we have to.
If Lordship kindly come to go to the top B2.
Yes,
Lordship.
And down below also is
Lordship,
there, but then it is very difficult to make out.
Yes, very
what is it
It
here?
has been reflected in the type copy. That is what. That at least it is exhibit 2. That becomes easier for us. It is difficult.
Where is it now? No, I just want to look at the contents. Maybe something wrong.
I don't know the come the deal come type on the video na. 25.
Coding statement. Oh, that will be in the CD, no? CD is here.
Ini 164, huh? Before the court.
Just look at this, right?
pembiayaan saya ni lagi pentingnya, there is different.
Tallies with this. Yes.
So before the court,
Exhibit 2, Exhibit B.
he has given one version that on the night incident I was in the house of my wife and left for the house of my wife's grandmother at about 9, which is a walking distance of about 15 minutes. Whereas in this 164 say that at about 9 p.m. I left my mother's house to go to my mother-in-law's house, where my wife also staying. So there's a big difference, my lord.
Have you confronted him in your cross on this?
There is nothing. It was not confronted.
Then?
Let me see the cross.
Yes, this is the cross there. But the fact remains, my lord, it is both on oath. Different statement, both on oath.
Oh, that is, you see, as far as oath is concerned, where statement under 164 is concerned, I think that is a debatable issue till today. Some says oath is not required, some says oath is required.
Yes.
We are not on that. What is material now is here, as far as statement under section 161 or 164 is concerned, they are only for corroboration and contradiction. If you can, and that has to be, that has to come out on the cross.
But anyway, I brought this on record that he kept two statements which indicate that he is unreliable person, my lord. Because when your lordship finish everything, then we'll see also that this accused is this person who claimed to be the eyewitness is unreliable person. So this is one of the point that he is unreliable person.
Only because he states that.
That is one. That is one. I'll come to other also. That is one. Is unreliable. Because it's a big difference going from the wife, from the mother-in-law, from the mother house to my mother-in-law house. That means he go from his mother house to his wife's place. And in this case also, because it is under evidence also that he stated that the accused, there is a smell of alcohol, and the victim also, there is a smell of alcohol. So on the other hand, he is silent about him because the police did not do anything as far as this particular witness is concerned, Your Honor. Your Honor. Because he stated that the accused person was under influence of intoxication. At the same time also, he said also that there is a smell of alcohol with the victim also, with the deceased. So there is every likelihood that he is the one who involved, because the whole episode and the whole incident has to be taken as a whole, my lord. Because what about the post-mortem report in which say that he died of asphyxia? Because this is by strangulation only, and whereas the material exists is wooden plank. At the same time, they say the firewood.
But nothing is on record to say that that wooden plank was the murder weapon. Nothing is said. No witnesses, nor the IO.
No, but he said he was struck by the.
Oh, he said that.
Assaulted by.
Strangulating a person. The rope is not always it is put from behind even to it.
Please.
But on the way, I met the victim, Rishanki BM, and he asked for a biri from me. Just before he lighted the biri, Rishanki BM was hit by one Aloysium, surprisingly. I tried to stop, but instead Aloysium told me that he will hit, and he beat me also. I got scared and ran away. Then, early the next day, I went to the house of the victim to inform about the incident, and only then I came to know that Rishanki BM is dead. When you go through the 61, 61 MD tu Rishanki tu dan ciba nak list. Ano? 1717. Dia tu bersibar terden gue. Tu under 61. Under 61 PNC tu under 61. Under 61. Tu ha. There was also a statement under section 161 CRPC of PW. Silent Tengkan, this already died. Willingson Dhar, Linus Sumer, Ram Renis Sucheng, Morning Langstang. This Willingson Dhar is a church elder. And in this case also, my lord, the statement is in page 33 to 36, my lord.
Where is the third copy?
Page 35. 35, page 35.
What is this?
Silent Tengkan is investigating into the murder case, so and draw a sketch map in my presence, I put my signature on the sketch map. Look at the sketch map under here. That must be there. Semle, some di je pa ko ro semyo.
Can you see this statement, Mr. Kinjing?
Pardon?
161 statement, can you see? Can we take cognizance of that at this stage? What the law says? Is it admissible?
But it will help because there is a
What the law says, if law does not allow us to see it, we cannot gather any help from there. You convince us that we can go through it and we can take help of this statement.
Yes,
as far as this court understands, we cannot. But since you are relying, so you have to show us which way we can.
I'll just I'll come to that later on. I'll try to convince the court.
First, you have to satisfy on the admissibility of this statement. Otherwise, what is the question of going into this statement?
Because the fact means that this is a job of the prosecution also to place before the court. Those things were not there. Because these are
what the law says, what the provisions of CRPC says about this statement under 161.
But
see section 162 of CRPC, read it and just explain it to us.
But the fact means that the court can see all those things, but they never supply to the defense.
Please see whether when court cannot see until and unless a witness is confronted with statement. That is what the law understanding of law of this, so far as my view is concerned, or our view is concerned. So you just say that. You say that it is at what stage it becomes admissible, at what stage we can look at it.
Yes, I'll look at
the law prescribes something. So you just point it out.
Yes, I'll look to that. But I'll just show first the irregularities. So I'll come to. I'll show all those things. I'll try to satisfy the lordship regarding those points. This morning, Langstung, my also in P36, examiner stated that his name is so and so, and murder near the roadside of Sapai, P36.
Yes.
Accused who was given threatening to him. Accused Aloysuyam was murdered Rishanki Biam with a firewood. Later, he left the place due to fear of his life and informed the matter to Linus Sumer, the father of the deceased, immediately. But all those things are the prosecution did not have. They have not come forward to. And it is not a fact like that. He did not come to inform.
Mr. Kinjing, as my brother has pointed out, you are referring to page 36. This is a statement under 161.
Yes.
So, to what extent you can rely on this statement? The admissibility of this statement.
That I'll try to satisfy your lordship another date. Right. Another day I'll try to satisfy all those things.
We'll continue the hearing next day.
Yeah.
We'll go after vacation then.
After vacation, your lordship. I am praying for after vacation, your lordship.
At least one day before vacation is still all right, no? If it's still, if your lordship can still come again.
I don't think we may have time. Because last sitting of this court will be on 11th.
On
11th. That's next week.
Okay, at your lordship.
Then after vacation, your lordship.
Heard Mr. K.S. Kinjing, Learned Senior Counsel, appearing for the apparent. Hearing the argument is yet to be concluded and as prayed for by the Learned Senior Counsel, matter the matter will continue on the next date fix. As prayed for by the parties, list this matter after vacation for further hearing.
Apply your lordship.
There is a decision by Apex Court in this, so far as 161 admissibility of is concerned. Please look at it.
Yes, sir.